Ask some about criminal law, and maybe a couple years ago we wouldn't have asked these questions so much because we feel an increase in crime and particularly murders lately. So you've granted several convicted criminals compassionate release during COVID-19 pandemic. In many cases, these inmates had violent criminal histories and were at very low risk of death or serious illness. And I've been involved with Senator Durbin on some of the being a little more liberal on criminal justice reform. So I don't take offense to it except how it may be administered. So just to take one example, U.S. versus Tucker, an inmate had a violent history, had already contracted and recovered from a virus. He also had both doses of Moderna vaccine. You still reduced his sentence by a year. So just kind of asking what goes through your mind. What is the legal basis for granting compassionate release to a violent felon who had been fully vaccinated against the virus and or are at low risk?
Senator Grassley, thank you. I have had many cases, as all district judges did, I think, in the pandemic, raising under the First Step Act motions for compassionate release. In all of them, I evaluated extraordinary conditions and then the 18 U.S.C. Section 3553A factors. In the vast majority of the cases of petitions for compassionate release, I denied. I do have some instances of having granted relief, including in the case that you mentioned. I did not actually, I suppose to be more precise, grant release, but I did, in conducting the evaluation under the 18 U.S.C. Section 3553A factors, reduce Mr. Tucker's sentence by a year.
Decisions to release convicted felons due to the pandemic have sometimes had tragic consequences. Now, you didn't have anything to do with this case, but let me tell you about one. A D.C. man convicted in prison for threatening to kill a woman was granted compassionate release. Last week, he found and killed the woman that he had previously threatened. How did you assess the violent nature of crimes committed and the risks that releasing convicted felons would pose to the communities released to?
Senator Grassley, I did evaluate, as I said, under the relevant statutory factors. I think if you look at the overall record where I denied compassionate release, it was because of an assessment of likelihood of dangerousness, which is a relevant consideration. In each of those cases, I listened carefully to the arguments that were being made by both sides, considered relevant precedent, and analyzed each instance individually under the relevant statutory factors. And dangerousness is a significant factor in that calculus.
Okay. Last year, you held that an undocumented immigrant could assert a state common law privilege against civil arrests near courthouses. Why, kind of a general question, why is the federal government prohibited from enforcing immigration laws near courthouses? But more specifically, can ICE enforce the law 2 blocks away from a courthouse or 5 blocks away?
Senator Grassley, I have to be a little bit cautious on this one because the matter is currently pending before me. But as you said, in the motion to dismiss posture, I denied a motion to dismiss. I concluded along the lines of another judicial opinion that had been authored in advance of mine that a claim had been stated for the longstanding, from the time of the founding, New York State common law privilege prohibiting civil arrests at the courthouse. And that case has not reached judgment yet. It's currently pending and on hold, pending the circuit's ultimate conclusion with respect to that other matter that I referenced that is ahead of me.
Okay. My last question. In a 2000 Law Review article, you summarized your understanding of Second Amendment law as it existed way before Heller. You suggested that there's no individual right to bear arms and that firearm regulation should be reviewed under a rational basis standard. After Heller and McDonald, how would you review laws impinging upon the Second Amendment rights, individual right to keep and bear arms?
Senator Grassley, as you noted, that was well before the Heller decision. I did summarize the state of the law at the time. Since then, the Supreme Court held clearly in Heller that there is an individual right to bear arms, and the McDonald case held that that is a fundamental right. Should I have a Second Amendment case or case raising those issues in front of me, without hesitation, I would fully and completely implement the Supreme Court's Heller and McDonald decisions.
Thank you.
Thanks, Senator Grassley. Senator Blumenthal.
Thanks, Mr. Chairman.